Hello and welcome everyone to Immigration Talk Show. I'm your host Sam, and today we are back again with another very exciting and very important webinar that is lined up just for you today. So make sure to watch this session till the end as we are live on YouTube and available on LinkedIn, Facebook, and on X as well. So don't forget to like, share, and subscribe to our channel, and our handle is at Immigration Talk Show. All right, before moving ahead, let me read out this very important disclaimer. By watching our videos, you agree and understand that the information provided by our experts and attorneys, including comments and replies from users, is not legal advice. So, use of information is at your own risk. All right, friends, once again, welcome back everyone to Immigration Talk Show. I'm your host, Sam. And today we are here with another very important and very demanding topic because most of the time we have been thinking every time about the H-1B, but we don't know the alternatives or we don't know about there can be some other visa categories also that you guys can opt for. So today we are going to have a very important and a very, I would say, interesting discussion on O-1A versus H-1B. Which visa is best for you in 2025? We all know in 2025 H-1B has been lots of challenges and there are lots of scrutiny also, but is it going to be the best path for your career? Maybe, may not be. Or is it O-1A visa? Or is it something else? I think till now the answer is not known, but I'm sure after watching this session, after having expert advice, we are really going to have a great answer and is definitely going to have a great guidance. So please let me welcome our today's very special and very honorable guest, none other than attorney Marcelo Gondim, who is a highly respected immigration attorney and the driving force behind Gondim Law Corp that is based in Los Angeles. He also has a years of experience and loves helping people with their green card and immigration goal. So, hi Marcelo, thank you so much for being here, and we are really honored that we are meeting for the second time in Immigration Talk Show. So, thank you so much for joining us.
My pleasure, Sam. How are you?
I'm great. How are you doing?
I'm good. Good to be here. Thank you.
Absolutely, likewise. All right, friends. So, till the time we are here for an hour, make sure to participate in the session by commenting and by asking questions that you have in your mind. And we'll make sure to take up those questions and we'll definitely give our best to answer it. All right, Marcelo. So, I think let's begin our very first question with this session. That can you explain what are the key differences between the O-1A visa and the H-1B visa?
Yes. First, they are both non-immigrant worker visas, mean temporary, not permanent. This is not a green card petition or application, and they have some very how can I say? They have some great differences that can make one better than the other for certain people. It really is not the case of being one size fits all, but in most cases, if people qualify for both, they might have differences that will make them, navigate towards one versus the other. So basically, the O-1A, it's 95% based on the capabilities of the applicant, the beneficiary, not the employer. So it only requires an employer or an agent. But the biggest difference between the O-1A and the H-1B is there is no lottery. There is no cap. There's no limit of visas that can be issued per year. So that makes a big difference because the H-1B, as we all know, you have to go through the lottery process, which starts actually in March 7th this year. And then if you are selected, if you are one of the probably 25, 20% selected, then you can apply in April and you can only start working for the employer in the first day of the next fiscal year, which is October of 2025, the first day of fiscal year 2026. The O1 doesn't have that kind of restriction. So you can start at any time. It's the same way as the H-1B takes about 15 days if you use premium processing to get your case adjudicated. Now, the other biggest difference, the other big difference between the O-1A and the H-1B is that on the O-1A, um, you don't have to test the labor market. So the employer doesn't have to prove that it could not find someone that it's offering comparable wages. None of those limitations apply to the O-1A. So it could be any salary, any form of payment, however the parties need to contract, they'll be fine. Um, but however, the thing that makes the H-1B a little better than the O-1A is the fact that the H-1B only requires the person to have a bachelor's degree, or sometimes they have a combination of a bachelor degree or education in experience, professional experience. That's the 341 rule. We're not going to go into that too much, but you have more people that could be applying for an H-1B than that could qualify for an O-1A. The O-1A is for extraordinary ability professionals, like people in the arts, business, sports. It's a wide range of possibilities, but you have to show that you are extraordinary. And sometimes you might think, well, I'm not, I don't think I'm that extraordinary, but your notion of being extraordinary might be different than what the immigration law says. So the immigration law has 8 criteria. You have to meet at least 3. Ideally, we should go with 5 just to make, to have some kind of a backup in case some of this criteria, they don't get approved by USCIS, then you still have 3 to support your petition. But it's really not that difficult. And some people that might not qualify for the O-1A at this point, at this moment, they can work on it. They can work around, the criteria, and actually they can get 2 or 3 criteria that can be easily established, so they will be eligible for the O-1A.
All right. I think that's very well explained the difference between the H-1B and the O-1A visa. But also, Marcelo, I would like to know it from you that just a random number, do you know any number that we know H-1B cases are uh, lakhs and lakhs, millions of people are applying for that. How many people are applying for the O-1A visa? Do you have any idea regarding that?
Well, we don't have the newest data from USCIS yet, but what we know is that it's much more than H-1B because,
Oh,
excuse me, because there's no limitation. So, but also not a lot of people will qualify. So it's roughly it's a little bit more than H-1B, but not like 3, 4, 5 times more because it's not easy to be extraordinary.
that's right. But also, Marcelo, can you clarify the term extraordinary? Because, our viewers are thinking extraordinary means to have Nobel Prize, to have Olympic award, or something exceptional. So, what does this extraordinary abilities mean in terms of O-1A visa?
Excellent question. So this criteria that you mentioned, they are also used for the O-1A, even for the EB-1, which is the green card. Excuse me, very similar to the O-1A, but in the O-1A, if you don't have an Olympic medal or an Oscar, a Grammy, or some kind of international award that is the best and most recognized in your field, you can still go for the 8 criteria method, where you can show at least 3. Like I said before, it's good to have at least 5 to be safe, but with 3, you can already qualify for the O-1A, and the criteria are not that difficult to meet. For example, one thing that sometimes raises the flag that that client might be qualifying for the O-1A is if you worked for a like a multinational organization, a company that
Mm-hmm.
is renowned, that is well known in the community. So if you work for large corporations in a leading, critical, or essential role capacity, you already have one criterion for the O-1A. And that comes with a second criteria right there, which is a higher salary. Normally, people working for these companies, they make more money. They have a
Mm-hmm.
higher salary. Higher salary is also another criterion that can be used for the O-1A. So now we have 2 already. So and then you can work your way out. For example, if you can manage to have publications, to have to write articles about you or written by you or about you. So some personal public relations, excuse me, public relations companies, they provide such services to allow you to be heard in the community, so you can have your articles published. So those articles are they make up to for one criterion, which is articles about you, and the ones that you write are articles written by you. So your authorship. So in this case, you have two more criteria there. Then you have some membership in
Mhm.
professional associations that require excellence for a person to become a member. So it's not just applying, pay a fee, and showing like a photo, and now you have your membership card. No, you have to have an invitation from some voting member, or you can apply, but then you have to go through a whole panel to evaluate your credentials to see if you deserve to be a member of that community. So this is another criterion that it's not that difficult to acquire, that it's available in many areas of engineering, many areas that normally use H-1B. You have those associations as well, international associations of electric engineering, automation, and all that kind of stuff. So you have many ways to go around. So now we already talked about five
Mhm.
criteria. So it's not that difficult to go and qualify for this, even though you might not think that you are extraordinary at this point.
All right. I think that's great. And also, Marcelo, I would like to know regarding the approval process. Which visa category do you think has a smoother and a better approval process?
Well, that's a very good question, and it's absurd to say that the O-1A has a better chance of approval than the H-1B.
Oh,
And it's not
so
because,
shocking.
yes, it's amazing because H-1B you just have to have a bachelor degree, and it's all about the position that you're going to occupy. So USCIS has some kind of I don't like to say it this way, but in my opinion, they kind of have a bad taste in the mouth with H-1B. So they sometimes some officers might try to find ways to deny that visa, even though all the elements are there. The person has the bachelor degree, the position for which this person is applying requires a bachelor degree normally in the industry, and even so, they try to find a way to they try to find a way to deny some cases. So it's not like uh, straightforward as it should be. Now, the O-1A can have a higher approval rate, but it needs to be vetted by the law firm handling the case. So we have a very high rate of approval on the O-1A because we choose who we're going to take as a client to do this kind of visa. We don't take just everyone. So we need to see at least, like I said, five. Some people go with three or four. We don't. We don't like to do that. We like to
Mhm.
work on five criteria at least. Some people come here with six, seven, or sometimes all eight criteria, and that's fine. That's great. But if you don't have the criteria, we're going to work with you first so that you can reach that high approval rate. And this is a good method, I think, because the H-1B, you cannot make the case better. The case is what it is. So you have a position, you have a bachelor degree, so it's straightforward, should be approved readily by USCIS. But sometimes, every once in a while, they pick on a case, some computer-based positions like in IT, they say, well, this position doesn't require a bachelor degree. And that comes out to another big difference between the H-1B and the O-1A. I know that we talked about the differences before, but this is another one that I forgot to mention. The H-1B, you have to have a bachelor degree. On the O-1A, you don't even have to have any degree. It's
Oh,
not based on study. It's based on achievements, accomplishments, awards, recognition. That's what the O1A is based on. And the H1B, you don't have to be special. You don't have to be extraordinary. You don't even have to be a good professional. You can be mediocre, and you still can get an H1B if you prove that you have a bachelor degree and the position requires a bachelor degree. That's all.
wow. I think this is something that we all didn't know because when it comes to O-1A visa, Marcelo, most of the people take a step back because they think they have to be highly qualified and they have to be highly exceptional in terms of working. But it's completely opposite. They have to do, I mean, they have to have accomplishments regarding their work, regarding their, I would say, the awards and those Nobel Prize, right? What they do mostly for the society. And for the H-1B workers, it's completely different. So thank you so much for putting up that, and that too in a very simple way, and that too very in a detailed way. I'm sure our viewers are understanding this thing, and now they will have this clear thing that which visa is going to be better for them. And also, Marcelo, as you said, that O-1A visa is easier, the process is simpler. So, can it also be the reason that O-1A visa doesn't have to do anything with the lottery system, whereas H-1B has a process with the lottery system? Can this be also the reason?
Yeah, well, I think the reason, I think no, I think no. I know the reason is that the H-1B is for everybody with a bachelor degree, so it's a very low bar for you to qualify because a bachelor degree is not hard to get in many countries.
Yeah.
So, but the O-1A doesn't even require a bachelor degree. However, you have to be extraordinary, and it's not easy to be extraordinary. It's not for everyone. So
Yeah.
one thing is to have people with a bachelor degree come to the United States to compete with US workers. And the O-1A, you're not really competing because it's only for extraordinary people. So it should be a limited number of people, not limited by law, but by, life conditions. So not everybody can meet those criteria and be eligible for the O-1A. So in this case, the O-1A is doesn't have to go through a lottery system because not a lot of people are expected to qualify. And in every country that I know, like to have people that are extraordinary moving there, and eventually, collaborating with research and in the profession in the field of endeavor, and that makes every country stronger if they have
Yeah.
more of those professionals moving to the country. The H-1B is more like not to have those high skilled workers. It's more like for the companies to be able to employ to fill their positions, which sometimes they can't find enough workers in the US. It hasn't been the case recently, but that's why I have only 65,000 H-1Bs per year, another 20,000 for people with higher degrees acquired in
Mhm.
the United States. So this is not even close to fulfill the necessities of the economy of the United States at this point. No, there was a time that the H-1B was 195,000 visa. I believe that um, inflated number of visas available expired in 2007. I could be wrong because I'm just taking this out of my head now, but I
Yeah.
think it was 2007 that the law changed. The law expired. There was the increased number of H-1Bs, and then it came back from 195 back to 65,000, which is nothing. We're talking about almost 20 years ago.
Yeah.
So in 20 years, the needs of the companies in the US, the demand for employees, it's even higher, much higher as you can imagine, and the numbers is still the same. And the O-1A, you don't have this problem, but you have to find people that are extraordinary.
That's right. So, Marcelo, the clients, those who come to you, they mostly ask for the H-1B applicants or for the O-1B visa category?
If they ask for the, I'm sorry, I got a bad sound.
That's okay. That's okay. I was just asking from your experience that you are immigration attorney. So the clients, those who you get, they came for you. I mean, they came towards you for asking the H-1B visa category or for the applying the O-1 visa category. I mean, which category do they demand from you?
Yeah, well, so sometimes they just send a resume. We have a system that people can see what they qualify for, and
Mm-hmm.
they send the resume through our system. We take a look at it, and then we say, well, you qualify for this, and this. These are not options for you. So now we kind of narrow down to a couple of options, and then we evaluate those options with them. Most people don't know much about the O-1A.
Yeah.
So sometimes they come for the H-1B thinking that that's what they have to go to the lottery system and all that stuff, but they actually qualify for the O-1A. So another thing that they sometimes don't know about is that the O-1A doesn't have a limitation the number of years that you can get. The first term is 3 years. Then you can have 1 year increments forever. You can be renewed every year. So you know that employees from India and China, they suffer with the H-1B because they get the H-1B, they can only be here for 6 years. Then the company files the EB, the green card, process, the case. And if they don't have a certain phase on the EB2 or EB3 case filed, they cannot extend the status past the 6th year on
Yeah.
the H-1B. The O-1A doesn't have that problem, and you can be renewing every year afterwards. So many companies like to have Indians and Chinese working there because the visa backlog is so huge on the visa bulletin that they can have that employee almost like I'm not saying that it's like slavery situation because they're getting well paid, but they don't have a lot of rights. They don't have a lot of freedom to work for whoever they want. So they have to be in that company. They can change employers on the H-1B and the O-1, but sometimes they don't want like to change employment because then the EB case goes away. So they have to be working on in that company forever for sometimes
Mhm.
5, 6, 10 years, 15 years, sometimes even 20 years. I've seen some cases. So it's really not a great idea if you think about it. But the O-1A, you don't have the limitation.
Yeah.
Also, on the O-1A, you can open your own business. And that business can be your employer, which can also be done on the H-1B, but with a certain degree of difficulty. Normal H-1Bs are not done like that. But the O-1A, you can actually open a business, have a partner, and that business is going to be a petitioner. So you are free to provide services through the company to whoever you want in the United States. So even that flexibility is a great difference between the two visas. But the clients come to me sometimes not knowing about the O-1A. And when I see that they worked for a multinational organization on
Mhm.
some kind of critical or leading role as a manager or team leader, some kind of some kind of leading position, that raises the flag. Well, that client might be a candidate for the O-1A. So
Mhm.
let's analyze this option instead of just looking at the H-1B, which is what they came from. They came for the first time around.
Absolutely. So, is it, Marcelo, that people don't know much about the O-1A visa? That is why O-1A visa is not highly in demand because, most of the time we have been seeing everywhere how to apply for the H-1B visa applicant, what are the eligibilities for H-1B workers. So, everywhere it's H-1B, H-1B. But O-1A has really a great, I would say, facilities and everything. So is it that people don't know? And if they don't know, then what do you think? Why they're not much aware about O-1A visa category? Because O-1A visa is much better and easier as compared to the H-1B visa.
Yeah, well, it's a matter of so some people they see the word extraordinary and they think of themselves not being extraordinary. So this is a long bridge. This is a bridge too far for me. It's a long
Yeah.
shot. I can't go to that for that visa. So the
Mhm.
H-1B is like much simpler. So I'm gonna go with this one. And it's really misleading the word extraordinary ability because the criteria are not that difficult to meet. So sometimes if you try the H-1B this year and you don't get selected, which is most likely the case because you have 75% or 80% of chance of not being selected in the lottery,
Yeah.
then you
Mhm.
can work in this next months, the next few months, to meet the criteria for the O-1. So next time around, by the time the next visa cycle for the H-1B comes about, you're already an O-1A visa holder.
Mm, that's right. All right, I think that can be the thing, and that's very well put up, Marcelo. With that, I would also like to know regarding the permanent residency because this is another question that most of the people go because if they are willing for the H-1B visa applicant, they look for the permanent residency. So, which visa offers a better path to permanent residency? Yeah.
Well, the H-1B has a clear path because normally the employer that wants the person for more than 6 years will have to start some EB2 or EB3 or EB1, whatever, in the meantime.
Hmm.
So if they don't do that, then by the 6 years, the person will have to leave the country and stay out for quite some time before they can reapply for the H-1B program. So this is not good if you really want to keep that employee, if it's a valuable employee. On the O-1A, you don't have that. Sometimes you have your own company, so that's going to be a problem for you to go with that company and apply for you in an EB2 or EB3. It's not going to be easy, but you can also apply for the EB2 national interest waiver on the O-1 because Sometimes if you have your own company, that endeavor is your endeavor also to demonstrate national interest waiver, eligibility for the national interest waiver on the EB2 and IW, which is one that doesn't require an employer. You can do like as a self-petition. Also, if you are working on the O-1A for an employer, the employer is your agent for the O-1A. In most cases, that person will qualify for the special EB3 or EB2, which is called the EB3 Schedule A Group 2. This is a select group of people that don't have to go through the labor certification process on the regular EB3. The company doesn't have to test the labor market because that person is extraordinary. So in the EB3 language, they talk about exceptional, but it's just almost the same criteria of the extraordinary ability on the O-1A. So in that case, you can have an EB3 case filed in about, say, 6, 8 months by your employer, and then you skip the whole advertisement, recruitment, all that stuff that has to be done on the EB3 and the labor certification application. You skip all that and go right to the second phase, which is the petition, the I-140 petition. So that's a great advantage on the O-1A. You can have the same criteria. If you meet the same criteria for the O-1A and you have the H-1B, you can also benefit from the faster EB3, but sometimes it's not the case.
Absolutely. I think, yeah, that's correct. And that's really, I would say, very understandable the way you put up, Marcelo. So thank you so much for explaining these things, and that too, very hidden things. Most of our viewers don't know much about it. So I hope that this session is really being insightful. And friends, please go ahead and ask questions, put up your thoughts on the comment section, because it's really a very, I would say, interacting session. And I really want, more comments to be here so that we can also have a better discussion and can also deep dive into the topic. But till then, I can see Marcelo, some of our viewers have joined. David is here, Rajendra is here, and Kunal is also here. So I think after some time, I'll take up these comments. But till then, here's some another question that I would like to know it from you, Marcelo. And this is regarding, yeah, about salary and job negotiations, as this is the most important and most demanding question that every applicants have in their mind. So does having an O-1A visa give individuals an advantage in salary or job negotiations because of their extraordinary talent? What do you say?
Yeah, of course. It's not easy to find extraordinary people. So if you are really extraordinary and that
Hmm.
company needs someone with that level of extraordinariness, in this case, you can negotiate a better salary. In the H-1B, you only go for what the bachelor's degree is requiring. So there are some guidelines from the Labor Department about what's the minimum for that code, the occupational code. On the O-1A, you don't have that limit. So it can be less than an H-1B, it could be more. But just because you are extraordinary, you
Hmm.
have a lot of leverage to, especially if you have your own business and you're going to be just rendering services, providing services, and getting paid as a business, then you
Hmm.
can name your price. And if the person knows that that business, that service is going to be provided by someone who's extraordinary, they much more likely would like to pay the higher fee so that they can have the extraordinary service.
That's right. Okay, let me go ahead with another question, and that is, what are the differences in the process of switching employers for individuals on an O-1A visa as compared to those on an H-1B visa?
That's also a good question. On the H-1B visa, it's a little simpler because you just have to file another petition, another form I-129. As soon as USCIS receives the form I-129, you can start working for another employer, for the new employer.
Mm-hmm.
However, if the case is not approved, then you're now out of status. You need to leave the country in some cases. But the job starts when the petition is filed. So it's about a 7-day period between the LCA, the labor conditions applications, to be certified, and then the company, the new employer can file, and then you can switch right away, and you keep in your H-1B status. On the O-1, it's not that simple. You need to file a new O-1A, and wait for it to be approved. So it's good to use premium processing service so you can get the new petition approved in 15 days.
That's right. I think to me, Marcelo, H-1B visa has some challenges and great opportunities, and similarly, O-1A visa also has great opportunities and great challenges as well. So it's like a balance of both the things. It depends upon their situation. It depends upon the applicant's desire, what they want. It's not exactly the answer that O-1A is best for you or H-1B is best for you. What do you think about it?
Yeah, it's sometimes a matter of convenience too. So some visas are more convenient. You don't need to have a sponsor. The O-1A, you don't need to have a sponsor. You can be your own sponsor by opening your company. There are
Mhm.
some caveats though that you have to be concerned about, which is, for example, if you want to open your own company, you need to have a partner with
Yeah.
administrative powers to hire and fire. And that partner can be a minority partner, but you have to have a partner. On the H-1B, you don't need that, yeah, but you have to have an employer.
Hmm.
So these little nuances between one and the other will make it sometimes more convenient to go for the H-1B than to go for the O-1A, and sometimes all the other way around. So the O-1A is more flexible, it's you're more free, but also you have to work on how to go from there to the green card when the
Yeah.
H-1B has already an established path for green card through the EB2 or EB3. But you still depend on the employer who is gonna that's gonna file the petition and follow through with the case. So it's really a matter of convenience, and sometimes not even a matter of convenience. Sometimes it's a matter of you don't have the choice because you
Yeah.
don't have an employer, or
Mhm.
sometimes you don't have a bachelor degree, but you are extraordinary. So the H-1B is not even a question for you. So you're gonna go for the other one. Sometimes it's a matter of um, people also who have the H-1B. They're about to expire the 6 year program, so they can try to get the O-1A, so they can stay in the U.S. longer and don't have to go through the lottery system again. So it's all a matter of each case is different. It needs to be analyzed individually.
Absolutely. And I think, friends, it's a very important thing. It's a very important task also for you to decide that which visa category is going to be best for you in this year in 2025. For that, I'm sure the session is really helping you out. But even to make you understand in a better way, you can also contact attorney Marcelo Gondim, and you can reach out to him directly and ask for any question regarding O-1A visa, or if you want to apply for the H-1B visa applicant. I'm sure he is going to provide some expert advice and would really going to help you out in your immigration process. So please contact him on the given number, that is 323-282-7770. And the email ID is frontdesk at gondim-law.com. And the website is www.gondimlaw.com. So I'm sure that you guys will definitely reach attorney Marcelo Gondim. Till then, I think let's take a quick short break and we'll be back here after some time. Till then, friends, go ahead, post your questions, and we'll be coming back again and we'll continue taking your questions. So don't go anywhere. We'll be right back. I'm Sam, joined by none other than attorney Marcelo Gondim. Keep watching Immigration Talk Show. Hello and welcome back, everyone, to Immigration Talk Show. I'm your host, Sam, and today joined by none other than attorney Marcelo Gondim. And today we have a very important discussion, and that too very demanding as well. That is O-1A versus H-1B. Which visa category is going to be best for you in 2025? So, till now, we have discussed a lot of things regarding everything about the requirements, eligibilities, challenges, opportunities, benefits, perks, salaries, and so many things till now. So I'm sure our viewers are having a better picture regarding both the categories and both the visa categories as well, which one is going to be helpful for you. And with that, friends, let me go ahead with the comment section also because we have already covered one part of this episode. We taken some questions. So I think Marcelo, let's go ahead and take up some viewers' question. What say? Okay, so let me take this one. David's one. So David is asking, I am an AI researcher with a PhD and about 10 published papers. I have heard that the O-1A visa is a good option for people with extraordinary ability, but I also qualify for an H-1B. So what are the key differences in terms of processing time, employer sponsorship, and long-term immigration prospects?
Well, the H-1B, you're going to have to go through the lottery system, which is going to open. Registration is going to open in a few weeks, on March 7th. It's going to go to probably around 21st, 22nd of March, and then they have the lottery. If you are selected, you can apply in April, and if approved, then you'll be able to start working in October. With the O-1A, you can be here in a few months already working, and you can even open your own company to conduct research or to conduct business or to really provide services in AI. So the O-1A is much more flexible at this point, and you shouldn't have a problem getting this O-1A. As a matter of fact, if you later also apply for the EB-2 National Interest Waiver as a PhD holder with the publication papers that are published and everything, you should easily qualify for the EB-2 National Interest Waiver. In that case, should also be approved. The EB-1A is also a solution, which is the counterpart of the O-1A in terms of immigrant versus non-immigrant visa. And so you have so many options, but the H-1B is actually the one that limits your ability to be in the U.S. just because of the lottery system, but not because of your credentials. But based on your credentials, the O-1A should be a more flexible option for you.
Wow. I hope, David, you got your answer. In case if you still have any question or any follow up, then please go ahead and put up in the comment section and we will definitely take them up as well. Let's move ahead with Rajendra question, and he's asking that I'm in a profession that isn't traditionally associated with extraordinary ability, marketing analytics. I have a strong work history and a few industry recognitions. So would that be enough for an O-1A visa? Yeah.
Yes, there's no such a thing, with all due respect, there's no such a thing as my profession does not go for extraordinary ability. Every professional can go for extraordinary ability. And, and because of that, you probably meet some of those criteria already. Like we say, recognition, it's one of the the criteria. So you probably have more than 5 or 6 criteria and don't know. So you need to be evaluated for that
Mhm.
because marketing analytics, in my opinion, it's a profession that normally is associated with extraordinary ability, like every profession is. Remember, guys, we don't have to think that the profession is important or not important. That's not the point of the O-1A. The point is how you are in that profession, not how important the profession is. And market analytics is actually pretty important. So I'm surprised that he asked this question. He must be very humble, but it's not really a case of not being associated with the extraordinary ability. But even if you think it's not, you're probably wrong because what matters is in that field, even if the field is not important at all, if you are extraordinary, you qualify for the O-1A. So the importance of the field is not the main issue here.
Wow. I think that's beautifully explained, Marcelo, and thank you so much for shedding light on this perspective as well. It was really needed and it was really great of you. I hope, Rajendra, you got your answer, and make sure that obviously it's nothing such as extraordinary ability that you don't have, as what Attorney Marcelo said. With that, I would like to pick up Kunal's comment. He's saying that I'm currently on an F1 visa with STEM OPT. My employer is willing to sponsor me for an H-1B, but I also have strong achievements in my field. Would applying for an O-1A uh, be a safer bet to avoid the H-1B lottery?
Well, you have a good chance with the lottery because you have the extra 20,000. If you have the extra 20,000 visas that are available for being that, if you have a master's degree in the US, for example, acquired in the US, then you might be in a good position for the H-1B, but it's still not certain. And you still be competing with a lot of people. So if you have accomplishments, you have achievements, you should go for the O-1A because you don't have to wait to start only in October. I know you have the STEM OPT, and I don't know if in the question, we didn't see in the question how long he has the OPT. I don't think he told us
No.
that, but the STEM OPT can be up to 3 years. Okay, so normally you have 1 year and you can get a 2 year extension because it's the STEM field. However, even those 3 years might not be enough sometimes to get your green card approved. So you're going to have to go to something. And if you don't get selected on H-1B, then the O-1A could be a safe solution for you. Um, I would say uh, it's better to have your professional resume analyzed by an immigration attorney so they can verify the credentials for the O-1A and for the H-1B. For the H-1B, fine, I know you already have that. But you depend on the lottery system. On the O-1A, you don't depend on that. Plus, if you have achievements, regardless of which one you go for the temporary visa, O-1A or H-1B, you can qualify for the EB3, the special Schedule A Group 2 EB3 or the EB2 National Interest Waiver. This one, sometimes I don't like it because it's discretionary, but for some people, like the other guy with the PhD in research, that one is good for him. But if you're not doing research, probably it's better to go for the EB3 Group 2 Schedule A Group 2 right after you get your approval, and maybe even before the O-1A or the H-1B, because the EBs, they don't really have anything to do with the temporary visa. You can have both simultaneously. You can even start your EB3 as soon as possible. So that maybe you get one term on the H-1B or one term on the O-1A. You don't have to be extending these visas any longer.
Wow, that's wonderful. Thank you so much, Kunal, for asking this question, and thank you so much, Marcelo, also for putting up these answers very patiently and wonderfully. Rajendra is saying thanks a lot for this clarifying. I mean, thank you so much, Rajendra. I hope this session is really helpful for you. And go ahead and post your questions, and we are definitely going to take them up. Let me take Renuka's comment here as well. Renuka is asking for an O-1A, do I need to be in the US while applying, or can I apply from my home country? And does that change the chances of approval?
Well, that's a very good question. You can apply from here, from the US. If you enter the country with a temporary visa, you can apply for a change of status. And once the petition is approved, like in 15 days, if it's approved with a premium processing service, if it gets approved, then your status changes from whatever status you had before, and you're already holding O-1A status. If you decide to apply from abroad, which is also possible, then you have to go through two phases. The first one is the petition. Once the petition is approved, the consulate, the U.S. consulate or embassy that you named for this, will be notified so that you can go for the interview and obtain your visa on your passport. So, in terms of being a better chance, if you change your status in the U.S., it's probably a better chance than if you apply for. You can be approved. The immigration service will approve your O-1 no matter what. It doesn't matter for them. But the problem is you don't have to go through consular processing. Consular processing might be the problem for some people. So in some countries, the U.S. consulates are not approving the visas as fast as the immigration service already approved them. So the petition is approved, and the person goes for the interview to get the visa, and they put the case in administrative process. to evaluate everything again, which is not common, not even shouldn't even be legal to do that because they just have to put the visa on the passport if the person is not inadmissible. But they don't do that. They go above and beyond and they question many things. So it's not certain to get the visa on a passport just because the immigration service approved your petition. But when you're here, you're already in the United States, you change your status, you can get a change of status, which is much simpler, much easier, much faster, much better. And in that situation, if you're gonna stay in the United States for 3 years without leaving, you don't have any problem. But if you need to leave, go back to your country or visit another country, then you will need to stop by the embassy or consulate to pick up the visa to get readmission to the United States. So keep that in mind.
Absolutely. I'm sure Renuka will definitely note down this point and will look towards it. Thank you so much, Renuka, for your question. And I think till now we have covered a lot of comments from our viewers. So thank you so much, friends, for putting these questions up. And, we have taken a lot of questions from our viewers. Meanwhile, Marcelo, we also have Facebook group and there also we have lots of viewers who are constantly commenting there. So, with your permission, I would also like to move ahead with our Facebook questions as well.
Let's do it.
All right, that's great. So, Control, please share the screen and let us show some Facebook questions as well. Okay, I think till the time the Facebook question will be appearing here, Marcelo, I would like to come back to my own questions that I want to know it from you. That is it. What do we can see? I mean, people, those who are really interested in the creative or the entertainment field, which is the better choice for them, the O-1A or the H-1B?
Actually, for people in the moving pictures, for example, you have the O-1B, which is slightly different from the O-1A, same prerogatives, but the criteria are different. They have to have participated in some productions, have some accomplishments, there are some other criteria. We didn't cover those here. We spoke mainly about the O-1A,
Mhm.
but the O-1B is a good option for people that are professionals in the movie industry.
Wow. That's really exciting and that's really great. Thank you so much, Marcelo, for putting up that. With this, I would like to ask another question: that are there any differences in how spouses and dependents of O-1A visa holders are treated as compared to those of the H-1B visa holders, especially regarding work authorization?
Yes, that's another great question. That's a good audience. Oh, that's your question, right? So that's great from you to ask this question because this is really important for some people to make the decision between H-1B or O-1A.
Mhm.
The O-1A In the O-1A, the spouse is going to receive, and the children are going to receive the O-3 visa. O-3 visa never gets work authorization. On the H-1B side, the
Mhm.
spouse and the children will get the H-4, and the spouse can work once the I-140, which is on the EB case, the employment-based green card petition, is approved, then the spouse can work with the H-4. So this is a rule that we don't know if it's going to stand because this rule has been going back and forth with the courts and the Biden administration put this rule up again. I don't know if the Trump administration is going to keep this benefit for the H-4 spouses, but the O-3 doesn't have this benefit, unfortunately.
Right. And also, Marcelo, as you mentioned about Biden's and Trump's administration, I would like to know it from you. Do you think that, most of the people are being very concerned about mostly the H-1B visa applicants that 2025 is going to bring lots of changes and scrutiny under Trump's administration? Do you agree with this or do you have any other call with that?
Well, there's this whole concept that the Trump administration is going to be bad for immigrants in all areas, not only undocumented immigrants, but also people that are legal in the country and people who are applied to get legal status in the country. And this was the case in the first term. My question about the situation is regarding Elon Musk being involved with the administration. Some people are even calling Elon Musk the president, the de facto president, when Trump is just a name there. So that's what some people are saying because of the how much power he has in the administration without being elected for any post
Mhm.
by anyone. However, Elon Musk, with his companies like Tesla and SpaceX, he uses a lot of H-1B visas. So he's a big fan of the program because he used the H-1B visa to pay foreigners less than he would pay American citizens. So he kind of, we can say that he's misusing the H-1B program. And that's something that we have to see how this is going to play out because now you have a president who has been campaigning against H-1B, who has been
Mhm.
campaigning against immigrants in general, everything. And now you have someone who is actually probably dealing the cards. And this person is a fan of the H-1B program. So now you have a conflict in the top of the government. So we don't know how this is going to play out. So far, we don't have any indication that H-1B is going to have any change for good or for worse, for better, for worse. So we have to wait and see.
Absolutely. I think staying updated is really important. So, friends, please go ahead and make yourself aware regarding each news that's happening in the world of immigration. And you can also like, share, and subscribe to Immigration Talk Show because here regularly we post videos and post news updates that's related to immigration world. With that, Marcelo, we have another viewer who has joined us, and Vivek. So Vivek is here with a question that I believe the H-1B is transferable to a different employer while the O-1A is not. Does that mean the entire application has to start afresh for a job shift for the O-1A? Okay.
Yes, you have to file a new petition. However, remember that 95 or 98% of the case is already done because you have already been found to be extraordinary,
Mhm.
and the new case is just a change of employer. So basically, you have to file a new case, a new petition. You don't have to that thing about reclaiming the time that wasn't used. You don't have that on the O-1A, but you have to file a new petition. But you have all the criteria already. It's not going to be less qualified the second time around. If so, you're going to be more qualified.
All right. Thank you so much, Vivek, for participating in this session and putting up this question. In case if you still have any follow-up question or still have any other doubt, then please go ahead and put up that question in the comment section, and we will definitely take them up. So I think now, Marcelo, we should move ahead with our Facebook questions. So let me take those questions as well. So this is the comment that we got from Supriya. She's asking, I'm on H-1B since 2023 and I wasn't able to travel to India for stamping due to various reasons. Is it safe to travel to India now? Has anyone traveled to India recently for the first time H-1 stamp? I am employed on a contract position.
Yes. Well, I don't think we can answer this question at this point because we are waiting to see what's going to happen with the H-1B in the next few months because the administration just changed. I don't think there was a problem to go before
Mhm.
President Trump got in office. I don't know how to answer this question right now because I just don't have the data.
All right, that's all right. Thank you so much, Supriya, for your question. And we will definitely, in the next session, we will try to cover this question because it will take some time to understand also what changes or what new executive orders can come. Till then, keep watching and make sure to like, share, and subscribe to our channel so that you can be notified whenever we are going to have a next episode with attorney Marcelo Gondim. All right, next we have Priyanka's question. And Priyanka is here with Hi, I have Dropbox H-1B visa appointment on February 24. My previous visa was F1. Does that mean that I have to cancel the appointment and get in person interview date as per rule change on February 10, 2025? Yeah,
Well, it depends on the consulate where you're going to have the appointment. Sometimes they are waiving appointments for H-1B visa holders. So you have to check with the consulate or embassy where you have the appointment.
that's right. Okay, Priyanka, I hope you will be having, check with your consulate, and that will be the only option for you. With that, let's move ahead with another viewer that we got question from, and John is here. So John is asking, "Hi, I recently moved to Washington D.C. from other state. My status is F2 for my driving license DMV, asking ineligibility SSN letter from Social Security Office. Is it normal to apply for SSN ineligibility letter as a F2 status?"
Well, some states or some jurisdictions, they require you to prove that you don't have a social security. You cannot obtain a social security number in order to
Mhm.
give a driver's license because they require a social security number normally for a driver's license. And then that's why sometimes they ask you to show that you try to get a social security number, but you're not eligible.
That's right. Thank you so much, Marcelo, for taking these questions. And these were some of our viewers as well from Facebook who has joined us and asked these questions. I hope they got their answer. Thank you so much, everyone, for being here. And with that, I would directly come back to our another viewer who has put up a follow up question. Vivek is here. So, Vivek is asking, if you have a non cap H-1B job, can you also work at a non cap organization alongside? How can you do so? I mean, cap organization.
Yeah, if it's a CAP exempt organization and the second one is also a CAP exempt organization, you can do so, but you have to file a supplemental H-1B.
That's right. Okay, thank you so much, Vivek, for putting up this question. And I think we have covered all our viewers' question, that too including Facebook and that too including YouTube as well. So, Marcelo, with that, I think we already covered, so many questions, and I'm sure it was really a very insightful episode. And you too have shared a lot of informative discussions and informative news, that too very eye-opening information. So I really enjoyed this episode. And before leaving, is there any message, is there any advice or any tip that you would like to share with our viewers?
Of course, don't look at the words extraordinary ability and think that you don't qualify. Try to work to qualify. Try to work yourself out to get to that point, and you'll be able to apply for an O-1A visa in probably less time than it will take for you to get a degree.
All right. I think that's great. And I hope our viewers are really going to have that advice with them. And with that, Marcelo, I'm so sorry, but I just need to wait for one more minute because we have another viewer who has joined us. So Vishwanathan is here and he's asking a question that, good morning. Do we have any delays in L1I-129 premium processing of petitions? Mine was received on 2nd, 2/6. Yeah.
No, the premium process is actually a contract between the petitioner and the government. So the contract says if they don't issue a decision in 15 days, they have to refund that money to you. So and they refund the money. They do refund the money sometimes,
Mhm.
but they normally comply with the 15-day. Remember that if an RFE, request for evidence, is issued within the 15 days, they comply with the 15-day rule. However, once the petitioner responds to the RFE, to the request for evidence, the 15 days is going to start to count again.
That's right. All right. Thank you, Vishwanathan, for participating and putting this question up. I'm sure you are, you got your answer. In case if you still have any follow up or, want to know more about this topic, then please go ahead and put up your question on the comment section. Till then, Marcelo, we already crossed 1 hour and it was really a very informative and very insightful session. I really enjoyed. I hope our viewers have been getting to know a lot of things from you. So thank you so much for being here. It was really our honor that you joined us again in the second time to Immigration Talk Show. So thank you so much for being here.
My pleasure. Thanks for having me.
Absolutely. And our friends, it would be great if you could directly contact or reach out to attorney Marcelo Gondim on the contact number. That is 323-282-7770. And the email ID is frontdesk@gondim-law.com. With the website also, you can visit his website, that is www.gondimlaw.com. So thank you so much, everyone. Thank you so much, Attorney Marcelo Gondim, for being here and putting up such a, I would say, eye-opening facts, and making this session a great one, a wonderful one. So we are really glad that you're here. So thank you so much for joining us.
My pleasure. Thanks.
All right. Thank you so much, our viewers, also for being here and participating in today's session. I can see Vivek, then Vishwanathan, Kunal, David. All of you guys have really put up a lot of interesting questions and made this session even more interesting. Make sure to like, share, and subscribe to Immigration Talk Show. We are on YouTube, LinkedIn, Facebook, and on X as well. And we'll be coming back with another very exciting webinar that is lined up just for you at 2 p.m. EST with another attorney, Alessandro Giordano. So please go ahead and join that session as well. And there we will know about like how you can protect your immigration status in this year, 2025. So till then, thank you so much, everyone. It was really a great session. Don't forget to like, share, and subscribe to our channel. And goodbye, everyone. Take care and stay tuned.